You may be a parent or a grandparent who have got huge sums of wealth, or you may have a lot of assets or properties, but you are worried about how these assets or properties or wealth will be passed down to your loved ones when you are gone. You may also find the terms will or family trust confusing or overwhelming to you. Well, you are not alone. There are so many people who face this dilemma, unsure about the best way to ensure their loved ones are taken care of when they are gone. This video will break down the complexities of wills, family trust, providing you with the knowledge to make informed decisions about your family's future. But here is the catch. Choosing the wrong option could mean your family faces lengthy legal battles, hefty taxes, and unnecessary stress during an already difficult time. Stay tuned to discover the best option to secure your legacy. This video is divided into three sections. The first section will assist you to understand wills. The second section will assist you to understand family trust. And then the last section, which is section number 3, will help you to choose between the two options. In other words, the first section is discussing wills as an estate planning tool, and the second section will discuss family trust as the second tool of estate planning. Then in the third section, I'm going to give you a verdict as to which of these two options may be appropriate for you. So let's dive into our discussion. The first discussion, as I have alluded in the introduction, is going to focus on wills. First of all, let's start with the basics. What is a will? A will is simply a legal document outlining the wishes of the testator uh, with regard to the distribution of the assets or property to the loved ones when the testator has passed away or is gone. What are the advantages of a will? The first advantage of a will is that it prevents family disputes. A well-written will can clearly state your wishes, reducing the chances for misunderstanding among your heirs. The second advantage of a will is that you have the opportunity to nominate a guardian for your minor children. You can legally designate someone you trust to care for your minor children when you are no longer around. Then the third advantage of a will is that you can also nominate an executor for your estate. An executor is an officer or an official who have got the responsibility to administer deceased estates. That is from the point of reporting the estate to the point where the estate is finalized and your beneficiaries have received their inheritance. Then the last advantage of a will is to do with the freedom of testation. This gives you the control over how your estate is going to be distributed. This is one of the most important principle in our law. It allows the testator the freedom to dispose his or her estate in the manner he or she wants. You can donate the estate to your one child. You can disinherit one of your child, or you can disinherit your spouse, or you can even donate the estate to a foundation without any problem, because our law recognizes the freedom of testation. So basically, these are the advantages of a will. But you also find that even if a will have got advantages, there are also some major limitations that a will has. And one of the major limitation of a will is the master process, or the probate process, as is referred to in some jurisdictions. This means that your will must go through the legal process, in this case, the master of a high court process, before your assets can be distributed to your loved ones. So, what is the problem with this process? You'll find that a lot of people dread this process. In other words, they fear the master process, or they fear the probate process. What are the problems with the master's process? The master's process have got a number of problems, and I'm going to deal with the three of them. The first is that to do with the public disclosure. If you are someone who believes that your private life must remain private, if you write a will, it means that your wishes will not be realized, because once you write a will, the will is supposed to go through the master office, and once it goes through the master's office, it means that it becomes a public affair. The information in your will be known by the members of the public, because the master's office is a public office, and anyone can access it and request some documents from it. So the privacy is taken away when you write a will and it is lodged with the master. Then it becomes a public record. Another disadvantage or limitation of the will is that to do with delays and costs. You may find that even if you have written a will, and you pass away, there may be some family disagreements between your heirs, and this can drag out the process, leading to some legal expenses, which can eat into your estate. In other words, the disagreements may result in third parties trying to assist your heirs to find each other. And in the process, those who will be trying to assist will be paid some money. The money they may be paid may actually deplete the whole estate, and your heirs may receive nothing in the process. Or because you have written a will and there are some disagreements among your heirs, and in the process the estate is going to incur some costs which may eat away the whole estate in the process. Then the last disadvantage of a will is that of the executor and the master's fees. You find that the master of High Court is entitled to receive some fees from your estate, because the office will be playing a role in the finalization of your estate. And in terms of the law, the current law, the master is entitled to 4% of the value of the estate, of the deceased estate, as fees. And the executor is also entitled to 5% of the value of the estate. That's a whooping 9% dilution or depletion of your estate. Um, and it's all because you have written a will, and your will has to go through the master's process, and this is how it then attracts this cost. And just think of it: if your estate is valued at 1 million, it means that the fees of master together with that of the executor will eat away 90,000 USD. So you need to think about it before you pen or you write a will. So basically, this is the first section discussing about the will. What are its advantages and what are its disadvantages? In the next section, I'm going to discuss the family trust, which is an alternative to a will. But before I discuss that, I encourage you to subscribe to the channel, hit the notification bell, like the video, and share the video with your friends. If you like this video and subscribe to the channel, YouTube is going to share this video with a larger audience, thereby ensuring that a larger number of people benefit in the process because of your liking, your subscription, and your commenting. So let's come back to our uh, next discussion, the family trust. A family trust is a powerful alternative to wills. What is a family trust, or what is a trust in general? A trust is simply a legal agreement where you transfer ownership of your assets to a trust managed by a trustee for your beneficiaries' benefits. Uh, why do you think a trust can outshine a will, or why do you think a trust is an incredible alternative to wills, or why do you think a trust outshines wills? The first advantage of a trust or a family trust is that um, it observes privacy, because a trust is a contractual relationship between the trustee and the founder. It means that the document will be a private document, and how the estate is going to be distributed remain confidential. So that's one advantage of a trust. Another advantage of a trust is that you avoid probate or the master process. The assets that you leave in your trust will be distributed to your beneficiaries more quickly, and without a lot of costs and delays due to the master process or a probate process. The issue here is that when you create a trust, the master's process is not involved. Hence, it will be very quicker for the assets that you leave in your trust to be distributed to your beneficiaries. Then another advantage of a trust is that there is perpetual succession. The trust will continue even after your death or the death of the trustee, because once your trustee dies, another trustee can be appointed, because this will be provided for in the trust deed, thereby ensuring that there is an ongoing management of your assets in the trust, and that these will be distributed to your loved ones without a problem. Then another advantage of a trust is that there are some potential tax benefits. A trust can offer tax benefits for your surviving spouse from the laws of our jurisdiction. Then another advantage of a trust is that it offers some incredible flexibility in how the assets will be distributed to your loved ones. For example, you can provide in your trust document that your trustee is obligated to make an outright distribution to your loved ones when you are gone. In other words, you do expect the whole capital amount of the trust to be distributed to your beneficiaries when you are gone. You can provide any that there be an ongoing support for your minor children. If you leave minor children, the trustee is expected to give an ongoing support to the minor children, and then after they reach the age of majority, then there may be some distribution to be done from the capital. Then another provision that you can put in your trust document, which also demonstrates some flexibility, is that you set up some distributions at intervals. Maybe you can say if your child reaches 18 years, you distribute 25% of the assets, and then when he or she reaches another age, maybe 30 years, you distribute 25%, and then when he or she reaches 30 to 40, you distribute 25%, and then the remainder will also be distributed after reaching maybe 50 years. Then the whole 100% is distributed. You can also establish a legacy trust to provide ongoing income to beneficiaries. In other words, a legacy is simply a trust where the capital amount or the principal amount is not distributed. The beneficiaries will only receive income that is generated from the principal amount. And then from that legacy, you can see that the trust can outlive the beneficiaries. In other words, you can create a trust that is going to cater for your children, your grandchildren, and the great grandchildren. That's how flexible a trust can be. Then the last advantage of a trust is that it assists you to protect the estate from irresponsible spending or from unforeseen circumstances. So you can provide in your trust to protect irresponsible spending or unforeseen circumstances by providing provisions like spendthrift provisions, which prohibits your beneficiaries to encumber their right to receive benefits from the trust by borrowing and submit that right to receive benefits from the trust as security. You can prohibit that. You can also require your your beneficiaries to undergo financial education before they receive a windfall from the trust. Uh, in that way, you will be assisting the beneficiaries to be able to handle the inheritance, and you'll be controlling how these things will be done even if you are gone, because you'll be providing that in your trust deed that you need beneficiaries to undergo financial education before they can receive the benefits. And then another provision you can put in your trust deed, which can protect irresponsible spending, is to require your beneficiaries, before they receive any money from the trust, to undergo drug test, so that you can be the trustee can check if the beneficiary is not abusing drugs, because if the beneficiary is given a windfall and he have got the tendency to abuse drugs, the amount may be squandered in the process. He may squander, or she may squander the inheritance. So, or the beneficiary may use that windfall to hurt himself or herself. You wouldn't want to give someone a windfall to hurt himself or herself. So basically, these are the advantages of a trust. Before I go to the next section, where I am going to give a verdict as to which of these two options is the best option, I once again encourage you to subscribe to the channel, hit the notification bell, comment, and like the video. Your support is very important for this channel. If you like the videos and comment and engage with the video, and subscribe to the channel, YouTube will share this video with a larger audience. And a lot of people are going to benefit because of your engagement with this video. I encourage you to do so. So, which of these two options must you choose? I think you need to trust your legacy to the trust. While wills offer some protection, a family's trust stands as the superior option for safeguarding your family's future. If you have substantial assets, a trust is the way to go. So there is no doubt about it. We have highlighted up there the advantages that the trust have. The trust have got so many advantages. Of course, we may indicate that a trust have got the disadvantage that you transfer the assets to be managed by a trustee, and you lose control in the process. But if you look at the advantages, you can actually tell that a trust is the best way to go in these circumstances. If you still have a burning question about which of these two options can be an option, can be a good selection for you given your circumstances, I encourage you to send us a message on the numbers showing on the screen. You can send a WhatsApp message, or you can call us on those numbers, so that we can schedule a meeting where we can discuss and give you the best option given your circumstances. Don't forget, as I have indicated above, to subscribe to this channel for more insightful videos on protecting your wealth and the loved ones.